on the floor of the Supreme Court of the United States yesterday, the legality of President Donald J. Trump's sweeping tariffs imposed under the International Emergency Economic Powers Act, IEEPA, hung in the balance. The case presents not only a test of trade policy, but a broader test of executive power. The tariffs, central to Mr. Trump's economic strategy, are now under scrutiny as at least 5 justices, including conservative members, voiced serious concerns that consumer prices may have increased as a result. At the same time, a few justices appeared open to the notion that the president must retain some flexibility in foreign trade matters. Among those on the bench, Conservative Justice Brett Kavanaugh, a Trump appointee, suggested that the president may indeed require tariff authority as a tool of foreign affairs. You know, the president may need tariffs as a tool of foreign affairs, Justice Kavanaugh said during argument. That remark came amid pointed questioning from multiple justices about whether the IEEPA, enacted in 1977 and originally designed for national emergencies such as foreign hostile states or wartime asset freezes, actually grants the president power to impose broad import duties. Joining the discussion is Rick Woldenberg, CEO of the U.S. educational toy maker Learning Resources Incorporated and its sister firm Hand to Mind. His company is one of the plaintiffs challenging the tariffs in this very case. Thank you for your time. You were inside the courtroom yesterday as those arguments unfolded, and among the most striking elements was the skepticism displayed by conservative justices, Justice Amy Coney Barrett included, toward the president's asserted tariff authority. What caught your attention? Woldenberg replied that he was encouraged to hear what he called the drumbeat from the administration for many months, that foreign governments would pay these tariffs, that this was an emergency, and that the law gave the president this power. He noted, if you look at the act itself, there's no reference to taxes. And it's hard to believe that Congress was going to give the president a $3 billion blank check to write to be funded by Americans paying taxes. He explained his company's experience last year under the tariff regime. They paid nothing under what the administration termed non-IPA tariffs, presumably referencing non-IEEPA, non-standard duties. This year, they have paid roughly $14 million in such tariffs. Meanwhile, under what they describe as the AI pay regime, which may be a mishearing or misdesignation in the transcript, they paid about $2 million last year and expect roughly the same this year, meaning their total cost of tariffs has jumped from about $2 million to about $16 million. He added, we raise prices mid-single digits in our business. We want to keep our pencil as sharp as possible because high prices can keep the sign. Products out of some kids' hands. When asked how quickly the company might reverse a price increase if the court rules in their favor, he said they are attempting to anticipate the outcome. They are delaying price hikes on the normal cadence, given other rising costs such as healthcare and salaries, to avoid yo-yo pricing for their dealers and customers. And when asked about the scenario if they lose, he didn't mince words. Eventually, you're going to see less consumer choice for us. We won't be able to afford to hire as many people. It's going to accelerate negative trends in the economy, and I think that would be regrettable. The core legal question before the Supreme Court is whether the IEEPA authorizes the president to impose sweeping tariffs on imports purely on the basis of a declared national emergency stemming from trade imbalances and foreign competition, rather than from a more classic national security or foreign hostility rationale. Lower courts have already ruled against the administration. In one case, the United States Court of International Trade found in May 2025 that the Liberation Day tariffs exceeded the president's statutory authority. In August 2025, the United States Court of Appeals for the Federal Circuit rejected the administration's position in a 7-4 decision, holding that the IEEPA does not explicitly allow tariffs and that taxing power resides with Congress. The case is now a marquee moment at the Supreme Court, a potential turning point in how firm or loose the executive branch may be in deploying emergency economic powers. Legal observers say the ruling could upend more than just trade politics. Justices from both Conservative and Liberal wings questioned whether the claimed tariffs are effectively taxes regulated by Congress rather than regulatory or sanction-type trade measures. Justice Kavanaugh's remark that tariffs might be required as a tool of foreign affairs signals a willingness by some Conservative justices to leave space for presidential trade discretion. Nevertheless, the justices repeatedly asked whether there is any limiting principle in the statute, what standard restrains the president. If the statute allows sweeping tariffs, would Congress have been comfortable giving the president so broad a latitude? Business groups, including small toy makers and other importers, have pressed hard that the tariffs have created real-world harm, higher costs, planning uncertainty, and disrupted inventories. Woldenberg's company cancelled major expansion plans, delayed hiring, and reduced marketing in response to the tariff shock. If the court rules in favour of the plaintiffs, like Woldenberg's company, it may open the door to significant refunds of tariffs paid and lead to a sharp upwards revision of company planning and cost structures. Woldenberg is already expecting higher cost burdens in the coming year and is trying to smooth them out rather than sharply adjust prices for consumers. However, if the ruling goes against them, he warns the consequences could ripple beyond one company, reduced hiring, fewer product choices for consumers, and a drag on growth in sectors reliant on imported goods. The stakes go far beyond the toy industry. A decision against the administration could force a major recalibration of US trade policy and the executive's reach in economic diplomacy. The court's ruling may clarify or reshape the major questions doctrine, the idea that when a question of vast economic and political significance is at play, Congress must speak clearly to delegate authority. Alternatively, a ruling favouring the administration might reinforce broad executive discretion, allowing a president to use emergency statutes in novel ways to restructure trade relationships unilaterally. And it is not just trade. How this court defines the boundary between Congress's power and the president's may echo into other domains: sanctions, regulation of digital platforms, supply chain oversight, climate policy, and beyond.